Good day, everyone. This is Werner from the University of South Africa. Together with my co-author and colleague Kobus Joubert, we lecture on the program in forensic and investigative auditing. The purpose of this paper is to provide forensic analysts or investigators, and especially the novice ones, with indicators of the types of digital information that are considered important in a court and how to ensure evidence is collected in a fair manner for use in a court or in a civil forum under South African legislation. It is necessary to distinguish that in criminal investigations, the state must prove its case beyond a reasonable doubt. However, in civil proceedings, it should be proven on a balance of probabilities. The paper provides insight into the treatment of digital communication as an acceptable form of evidence in court and identifies some of the risks and the challenges for novice and expert forensic investigators when collecting digital communication as evidence. Living in the age of 4IR, we know technology changes constantly. I want to show two examples of devices which changed the world as we know it. Yet, their complex nature, given the era they were built in, remains a mystery. The first example is and I hope I pronounced this correctly, is the Antikatera Mechanism, which has puzzled experts since it was found in a Roman-era shipwreck in Greece in 1901. According to information available on the Internet of Things, it was a hand-powered ancient Greek device, the first analog computer with a complex gearing system made of brass. If we speculate about its use, it was most likely used to predict eclipses and lunar events, but whether it worked or not remains a mystery. However, the forensic analyst can speculate about its intended purpose, but proving its reliability would be much more difficult in a court. This is a good example of technology that keeps on changing the world as we know it, and how we need to adjust our understanding of this ever-changing world of technology. The second example is the Hardwell Decaraton computer. According to the Smithsonian, it is the oldest working digital computer in the world, built in 1951, making it 71 years old today. Sorry. Its design had already started in 1949, following the secret pioneering days of computing in the 1940s. This computer weighed 2.5 tons. That's about 5,000 pounds. Interestingly, this computer was known for its error-free calculations, and it wasn't even binary. It worked in decimal. It was built for reliability and not for speed, as it took approximately 10 seconds to multiply two numbers. Similar to the case of the novice forensic analyst investigation process, reliability is a key consideration when proving error-free calculations made by a machine. And I hope I pronounce it correctly again, the Antikatera Mechanism and the Hardwell Decaraton computer were ultra-complex machines for their time. They teach us that technology, even when considered to be very old technology, is still complex. But that brings us to the following point. What about the machinery of the law regarding the admissibility of digital evidence? Background and purpose. We pose the question, why is it necessary to inquire about the reliability and admissibility of digital evidence? The answer is plain: to help clear up legal uncertainty. When dealing with the reliability and the admissibility of digital information, such as emails or SMS, the forensic analyst must keep an eye on the chain of custody, meaning keeping a track record indicating how the forensic analyst collected the pieces of digital evidence. We were quite far with the development of the paper when we realized that social media information, such as tweets and WhatsApp, could not be excluded from the discussion. Therefore, we included social media messages to determine when do they fall foul of the common law principle of crimen injuria. The test to determine whether a social media statement falls foul and should be pursued for defamation is an objective test, as was held in Hanekom versus Zuma in 2019. According to the South African Criminal Procedure Act, the publication of a defamatory statement shall be admissible in evidence without future proof of its publication. Thus, defamatory statements are considered evidence when they can be linked to a specific person. According to the judiciary in S versus Brown, digital evidence has probative value if it is relevant and admissible to the matter at hand. This also answers our third problem statement later on. Although most of their work is conceptual, a novice forensic analyst must be aware of a plethora of legislation concerning evidence. This is the Antikatera Mechanism spoken of earlier, the system of rules regulating digital evidence gathering. Case law is critically important and must be studied. It is now time for a general quiz question. What was the name of the first South African case that dealt with forensic computer evidence? It was Nautilus versus South African Bank of Athens back in 1976. An appellate judgment. Here we encountered the first South African decision by the judiciary that dealt with the question of the admissibility of computer evidence in civil proceedings. In this matter, Judge Holmes remarked, well, a computer, perhaps fortunately, is not a person. Perhaps the judge meant that because a computer is not a person, it can't testify about its own experiences. It was held that a computer printout was inadmissible as prima facie evidence in court. This was a clear indication that the law regarding the reliability and admissibility of electronic data needed urgent correction, as the laws dated back to 1965. Research problems. Regarding the research problems, the following aspects emanate. Emails. In Spring Forest Trading versus Woolbury, the Supreme Court of Appeal had to deal with several emails sent in series, which purported the cancellation of a franchise agreement. The court applied the following measures in terms of the Electronic Communications and Transactions Act to allow emails as evidence. 1, emails must be in writing. 2, emails must be signed by the author. 3, an email must satisfy the requirements of writing. And fourthly, that the requirement of the signature is satisfied by the writing of the person's name at the end of the email. SMSs. The question before the court in Democratic Alliance versus African National Congress was concerned with the truth of the SMS under discussion. The court was not asked to rule on the authenticity of the SMS, but on whether the message conveyed by the SMS was true or false. Unless the author makes it clear that the SMS is an expression of opinion or comment, its contents cannot be protected by a plea of fair comment. For the forensic analyst, it is clear to establish at the outset whether the text contents, known as the facts of the SMS, are true before submitting it in court. And regarding the last question, it was answered earlier. Research methodology. The research methodology entailed a systematic literature review as described by Kirkwold. The review method consisted of an analysis of the relevant provisions of the Criminal Procedure Act, the Law of Evidence Amendment Act, the Electronic Communications and Transactions Act, also known as ECTA, the Constitution of South Africa 1996, the new Cybercrimes Act, and the common law together with court decisions and academic articles. Relevant court cases were selected from the LexisNexis Electronic Library database, as well as the Southern African Information Institute. This contains court cases. Findings. Before the contents of a document may be presented as the truth, the admissibility requirement must be fulfilled. Therefore, the contents must be relevant, no inadmissible confessions are allowed, or hearsay or opinion evidence. By the rule of law, experts can be called to testify on the contents of the email or the SMS. The golden rule is never to ask a question to which you do not know the answer already. Data messages cannot be merely excluded as evidence because of their electronic nature. Relevance depends on the form or the format and must conform to the rules stated in the ECTA Act. The forensic analyst must be able to explain the chain of custody of evidence when demanded in court. Prevention is better than cure. Robust cybersecurity protocols should be added to an organization's digital network. In terms of the Cybercrimes Act, a company must keep evidence of cybercrimes and at its own cost. Risks can be, however, mitigated by putting in place ICT policies and protocols to prevent future cybercrimes. In conclusion, forensic analysts should partake in developing sustainable policies and procedures for organizations to manage digital communication within the organization. Acknowledgement. I would like to thank Ishani Brown and Mike Armel for their assistance in organizing this special event. Also, my sincere gratitude to the Ontario International Development Agency for arranging this wonderful opportunity. I thank you.